The Made in Texas Suppressor lawsuit just received critical support from the Supreme Court, who issued a unanimous decision which constrained the powers of federal agencies and also the use of the Commerce Clause. So let's talk about this. But real quick before we jump into this video, if you think suppressors should no longer be regulated under the NFA, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Lear Capital. Last year was a terrible year for most investors, and 2023 could be even worse with the talk of an upcoming recession. One tool you can use to hedge your bets is investing in gold and other precious metals, and Lear Capital can help you with that effort. With over 25 years of experience and a risk-free guarantee that gives you 24 hours to review your purchase, Lear Capital is what I recommend if you want to get started in buying gold today. So head on over to Lear Capital by calling 1-800-920-8388 or go to learscholar.com to start purchasing precious metals today. As I mentioned in the intro, in this video we will be discussing the Texas Suppressor Freedom lawsuit, which aims to eliminate the NFA and the ATF's regulation of Made in Texas suppressors. This case that we're going to be breaking down is called Paxton v. Dettelbach, and also we're going to talk about how it just received some major assistance from the Supreme Court in a recent unanimous decision. The Supreme Court last week issued a unanimous reversal in a case called Sackett v. EPA. Although the Supreme Court unanimous decision did not deal directly with the Second Amendment, it will have significant impacts on two-way cases like the Made in Texas suppressor lawsuit. This decision by the Supreme Court signals that the majority of the court is on an active quest to constrain executive agency overreach, and also they are seeking to rope in the expansive use of the Commerce Clause. And both of those issues is exactly what's being dealt with in the Texas Suppressor Freedom lawsuit. Now, if you're not aware, the Texas Suppressor lawsuit deals with the state of Texas and a new law that they passed through House Bill 957. HB 957 aimed to exempt from federal regulation all suppressors that are made in and also remain in the state of Texas. HB 957 exempted silencers, which are manufactured in Texas and which remain in Texas, and exempts them from the federal firearms laws and regulations, including the firearms registration and the taxation and all of that under the NFA. The claim behind this law is that since these items are made, sold, and remain within the state of Texas, they do not fall under interstate commerce, and therefore they also fall outside of the purview of federal regulation by the ATF. Now, after Texas passed that law, the ATF sent out a letter essentially threatening that they will enforce the NFA and the GCA's requirements against any Made in Texas suppressor, and they will enforce it against anyone who buys, sells, or manufactures those items. After the ATF sent out that warning letter, Texas, through their attorney general, filed a lawsuit on behalf of Texas plaintiffs, and they sued the ATF. In the complaint, the state of Texas argues that federal regulation of these specific suppressors that are made and stay within the state is not permitted since this law does not impact interstate commerce. They also argue that the federal restrictions on these items by the ATF drastically impacts Second Amendment rights since suppressors are arms. Multiple times in this case, the ATF tried to avoid the burden of Bruin by arguing that the Second Amendment is simply not implicated in the case, and they said that it wasn't implicated at all because suppressors are not bearable arms in their eyes, even though the fact remains that under the NFA, suppressors are defined and treated actually as firearms, and the ATF treats them as firearms, i.e. bearable arms. This Texas suppressor lawsuit is currently being heard by a federal district court in Texas, and it's set to be decided on cross motions for summary judgment. Well, the state of Texas just received a huge boost of support for their arguments because the Supreme Court just issued a decision which touched directly on some of these legal issues. In Sackett v. EPA, the Supreme Court issued a unanimous reversal of a Ninth Circuit decision, and then 5 of the judges joined a majority opinion. That majority opinion constrained the EPA's ability as an agency to regulate beyond their expressly stated statutory powers. This decision also touched heavily on Congress's expansion and their expansive use of the Commerce Clause, and also agency claims that they have broad powers under the Commerce Clause to regulate economic activity that only happens purely within a state. In Sackett, the Supreme Court reviewed a case where a couple had attempted to build a house in Idaho, but they were essentially prevented from building that house because the EPA, as an executive agency, said that that property was wetlands, which fell under the Clean Water Act's protections. The EPA ordered the couple to stop building and then to restore the property back to its original state, And if they didn't do that, then the EPA would fine them up to $60,000 per day, and also the couple would face serious criminal convictions. The EPA classified the wetlands on the Sackett's lot as waters of the United States because they were near a ditch that fed into a creek, which then led into Priest Lake. The Sacketts sued, alleging that their property was not waters of the United States as defined in the CWA, and therefore the EPA as an agency did not have the authority over the ability of whether or not they could build on their property. On review, the Supreme Court agreed with the couple, they agreed with the Sacketts, but importantly for the Texas Suppressor lawsuit is some of the discussion about congressional and agency authority, which is established using the Commerce Clause. Justice Thomas and Justice Gorsuch focused heavily on the Commerce Clause in their concurrence. In the concurrence, they state that what happened to the CWA is indicative of deeper problems with the court's Commerce Clause jurisprudence. The eclipse of Congress's well-defined authority over channels of the interstate commerce tracks the court's expansion of Congress's power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Justice Thomas goes on to say that, as I have explained at length, the court's Commerce Clause jurisprudence has significantly departed from the original meaning of the Constitution. The clause's text, structure, and history all indicate that at the time of the founding, the term commerce consisted of selling, buying, and bartering, as well as transporting for those purposes. The meaning stood in contrast to productive activities like manufacturing and agriculture, and founding era sources demonstrate that the term commerce was consistently used to mean trade or exchange, and not all economically gainful activity that has some attenuated connection to trade or exchange. By departing from this limited meaning, the court's cases have licensed federal regulatory schemes that would have been unthinkable to the Constitution's framers and ratifiers. The court's opinion today curbs a serious expansion of federal authority that has simultaneously degraded states' authority and diverted the federal government from its important role as guarantor of the nation's great commercial water highways into something resembling a local zoning board. So Justice Thomas and Justice Gorsuch are saying that in the CWA and EPA context, the agency control claimed by the EPA goes beyond anything that the founders would have ever imagined or even permitted. Also, the traditional concept of commerce did not include activities like manufacturing or activities that have a loose connection of cross-state trade or exchange. That means that this rationale falls squarely within what Texas is arguing in their suppressor lawsuit. They argue that the NFA and the GCA do not regulate activities that occur exclusively within a state like Texas. Under the Commerce Clause, that is not possible, and the ATF certainly does not have the authority under those statutes to regulate pure state conduct, especially when it's simply just manufacturing. And that is exactly what the Texas Suppressor lawsuit also aims to deal with. It aims to rein in the claimed authority by the ATF that they can regulate all firearms and all firearms-related conduct, even if it loosely touches on NFA or GCA items or topics, and also even if the activity in question occurs exclusively within a single state, the ATF says that yes, they can still control that. So although the Sackett case did not deal directly with the ATF and the NFA and the GCA and all those items, I suspect that this specific case, the Sackett case, will eventually pop up in the Texas Suppressor lawsuit. It will likely be cited to because there are so many parallels between what happened in the Sackett case and what they were dealing with the EPA, and similar to what we're dealing with here with the ATF and the Made in Texas Suppressor lawsuit. And also, again, there was a lot of discussion about the Commerce Clause and how the Supreme Court wants to constrain the Commerce Clause. So again, a really interesting time in the legal world where some cases and some concepts are dropping now, where some things are changing, especially at a high level by the Supreme Court. And hopefully some of these decisions can now be used, can have ripple effects on other cases that do impact our 2A rights. But if we learn anything else, I will let you all know. And if you want to learn more about what's going on in the 2A world, you can watch these videos here on the screen. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.